And we are joined now by Stephen Schwinn. He is with the University of Illinois Chicago Law School. Thanks for joining us. We thought by now we might have had a decision made on what was going to happen, but much to our surprise, this is now taking some time. If you can, let us know how this works when the judge is obviously being very, very cautious about how she is handling this case. There's a back and forth going on. They both were able to present their cases, both sides, and now she is asking questions specifically. What can you tell us about how this all happens and maybe why she is handling it this way?
Sure. Thank you for having me. Pleasure to be with you. So what the judge is doing is testing both sides' theories, in particular the Trump administration's theory on why it needs to deploy the National Guard to Chicago in the interest of aiding ICE agents in enforcement of immigration law, and Chicago and the state of Illinois' arguments counter to that we don't really need National Guard here to help enforce federal law, that there isn't the kind of lawlessness that the Trump administration has said surrounds ICE enforcement in Chicago, and that the National Guard really aren't needed here. And so the judge is looking at both sides of the arguments and looking quite carefully and cautiously at both sides of the arguments to make the ruling. It's taking a little bit longer than what we might have originally anticipated, just because these are fairly complicated questions.
Let's kind of go through what's going on in the courtroom right now. We are getting some more correspondence that the judge is presenting some questions to the defense, and I want to get your reaction to this, Mr. Schwinn. So the judge has said, assuming every person who assaulted and vandalized federal authorities and properties committed an offense and they were arrested and prosecuted, you believe the president is unable to execute laws of U.S. Your understanding of execute is preventing. Okay? The defense then says we're not saying commission of one crime is evidence. This is repeat and harming DHS and property and overall mission. And the judge responds in this way. Riddle me this. Drugs have been dealt in Chicago for many decades. So that means the president has had the authority for decades to send in the Guard to assist DEA. What do you make of that exchange?
Well, I think it reveals that the judge is highly, highly skeptical of the Trump administration's theory here. What the judge is saying is, look, we've had crime in the city of Chicago, as there's been, in every community nationwide. Crime itself doesn't mean that the president needs to bring in the National Guard to enforce federal law. That just doesn't make any sense. There's nothing particular about this time on this day in this so-called emergency that requires the deployment of the National Guard any more than, an ordinary street crime 2 years ago or last week would have required the deployment of the National Guard. I think this reflects a high degree of skepticism on the part of the judge to the Trump administration's theory of the case.
And we're just seeing from the judge, a big issue for the defense today is not really being able to define what the National Guard is here to do. And the judge says, I expected you'd tell me they were here for immigration laws. Sounds like your argument could mean anything. So it sounds like the defense really has not come with an argument that was specific or tailored to what exactly they were going to do. I'm curious, Stephen, she's going to issue her ruling, which it's leaning towards she's not buying the Trump administration's argument. But in the ruling, do you anticipate, language that might resonate, that might, be kind of, because judges in these rulings, sometimes they say things like the Oregon judge said the facts, the Trump administration, something to the effect of they're not comporting with reality. So would you anticipate like a strongly worded ruling here that kind of sends a message?
It could be a strongly worded ruling, and certainly the judge seems to be leaning in that direction. I mean, the problem here is that the Trump administration has characterized the on-the-ground situation in Chicago in a way that is just not supported by what appear to be what is actually happening on the ground. And moreover, as you suggested, I think quite rightly, the Trump administration hasn't settled on a firm legal theory here. So on the one hand, it's saying that protesters are impeding federal immigration law enforcement. On the other hand, it's saying that protesters are creating a kind of rebellion. And yet, on another hand, we're hearing from the White House, although we haven't heard this in the court pleadings, but we're hearing from the White House that the president has inherent plenary authority to deploy military forces in the National Guard to a city like Chicago. That's an extraordinary claim. And I think what the judge is pushing back against is the idea that these claims, if they were to wash, if they were to stick, that would mean that the president could deploy the military and the National Guard anytime, anywhere.
Yeah, interview that was on another network where it was said that Donald Trump has plenary authority has now gone viral with people saying, wait a minute, you know, what exactly does this mean? I want to ask you this. It appears, obviously, we have to wait for the judge's ruling. But from everything we're hearing from that's coming out of the courtroom, as you have yourself stated, and it sounds like maybe that they are having a hard time trying to prove this. What happens if the judge does in fact say you cannot have the National Guard deployed in Chicago? You cannot have them where they are. You need to send them back. And then the Trump administration says, we're going to keep them here anyway, and we're going to go to a higher court.
So at that point, it's important to remember that everything that's happening right now is preliminary in the sense that this isn't a full-blown trial on the underlying merits. What Illinois and the city of Chicago are asking is for a temporary restraining order on the part of the court to prevent the deployment of the National Guard under Trump's orders. If the court were to issue a temporary restraining order, I would expect that the Trump administration would immediately appeal to the Seventh Circuit on an emergency basis and ask the court to what we call stay the lower court's injunction, basically put the lower court's injunction on hold for the time being. And if the Seventh Circuit were to reject that, then the Trump administration, I would expect, would go to the Supreme Court on the so-called emergency docket, or sometimes called shadow docket, and request the same kind of relief. But again, it's important to remember that in some sense, this is all preliminary, that we're not really dealing with the underlying merits. What we're dealing with is a likelihood of success on the underlying merits, that the underlying case will continue to move forward. Now, if the judge declines to issue a temporary restraining order, or if a restraining order is stayed by the Seventh Circuit or the Supreme Court, what would that practically mean? It would practically mean that the Trump administration could deploy the National Guard to Chicago.
Well, Paris, you were just looking up some, comments from the president that were made already this morning.
Right.
And it sounds like his plan is to keep the National Guard right here.
Yeah, he basically said, like it or not, if the governor likes it or not, we're going to keep the National Guard. We're going in. But again, they can't. I mean, if Judge Perry rules on the TRO, then they can't. But I want to also bring up a statement from the chief judge, basically to these rumors that National Guard is going to go protect the federal courthouse. The Chief Judge, Virginia Kendall, says providing access to justice is the heart of the court's mission and critical for our democracy. Maintaining access to the courthouse for anyone who seeks redress remains a top priority. It's a core principle to the rule of law. She goes on to say she is in charge of security. She has requested additional steps from U.S. Marshals to maintain security there. She has not requested the National Guard for the courthouse. And if the president sends a National Guard to guard the courthouse, that would be over the objections of the chief judge, Virginia Kendall there, who says it is her jurisdiction to decide that. So this is many layers here, in terms, and this plays into this hearing because Judge Perry is saying, well, I thought you were going to tell me they were here to just guard immigration, but it looks like you're not really defining what they're here for, and it could be anything.
And now the conversation about sanctuary cities is now playing out in court now, too. So the judge has asked the question about sanctuary cities and saying, does that mean conditions are met in every sanctuary city or state for, obviously, the National Guard being deployed? And the defense says, different situation, we're citing violence. And the judge says they're not. So it seems like, again, the judge is not on the side of the Trump administration on this. Paris mentioned, that the president has said that, the National Guard would stay. They would go to the courthouse is what we're hearing. What happens in that case from your perspective, Stephen? Is this then a battle of the courts to figure this out? Will it all play out in court from this point on, no matter, because it sounds like no matter what happens with this TRO, the Trump administration, specifically President Trump, wants the troops to be here?
It's a tough question. We've never really faced this kind of situation before, and so we don't really know how this would all play out. Ordinarily, an administration would comply with a lower court order pending appeal, and if they wanted to go ahead and appeal, they could appeal it, but they would comply with any court orders. If the Trump administration is declining to comply with a court order, it's difficult to know exactly what the enforcement mechanism would be then against the administration's deployment of the National Guard, again, against a court order. It also makes it really difficult to understand exactly what the administration's theory is here in deployment. It's looking more and more like the administration is taking a vast, expansive view of the idea of a rebellion or its inability to enforce federal law as a justification for deploying the National Guard in a broad, sweeping kind of way. I mean, for example, if the president were to deploy the National Guard to protect the federal courts, right? That's a pretty broad, sweeping theory of protecting against rebellion or enforcing federal law. And then just one final beat on this. If the administration's theory, as it may be suggesting outside of court, but nevertheless suggesting that the president somehow has plenary authority to deploy the military and National Guard, well, then the theory would say that even the courts can't restrain the president in doing that. That's a breathtaking theory. And again, we've never seen anything like that. And it's just not clear to me how it would play out.
And let's bring up more comments from the judge here, Stephen. The judge is saying we'd be in a different position if your argument had been we're having problems on federal property enforcing immigration laws. You have not narrowed that scope. I'm struggling to find out where this would ever stop. Help me understand if what you're proposing is really as broad as what it seems. So again, drilling down into this notion that the federal government has not really been specific. They've been very vague on what the purpose of the National Guard is. And the judge expressing some skepticism that, well, if it's just immigration enforcement, that is not what you're arguing today. What's your reaction to that exchange? The fact that the defendants still have not narrowed their scope of what the National Guard is here to do.
That's exactly right. And the judge is picking up on this and expressing frustration with the administration's lack of a kind of determinate focus on what the National Guard would do here and the theory for deploying the National Guard in Chicago. And I think what the judge is identifying is just a very vague theory of deployment. The administration hasn't really defined precisely why it's deploying the National Guard, and that might be because it just doesn't really have a great theory for deploying the National Guard. And so it's using a kind of scattershot, spaghetti on the wall approach to say, well, we need the National Guard to help with law enforcement kind of generally. We don't need to specify what that means, just kind of trust us, or that we need the National Guard to put down a rebellion of some sort that the administration has imagined. And, Judge, you should just basically trust us on that. And so the administration's theory here seems to be wide sweeping, kind of very ill-defined, and relying on a sort of trust us sort of claim.
Well, Stephen, before we let you go, with what we're hearing coming out of the courtroom, with what we've told you, it's sounding like maybe the governor is going to at least possibly get that temporary restraining order. Where do you see this going in the future? Right now, as I said earlier, there's also a court hearing going on in Oregon, and there's other states that will probably be having to deal with this as well. As you look at where we are now, what do you see coming up in the future with all of this?
It's a good question. And I think given that this is going on in Oregon right now, too, and there's a hearing going on right now at the Ninth Circuit about the Oregon case, similar kinds of questions are coming up, although maybe not exactly the same level of skepticism on the part of the Ninth Circuit judges that we're seeing here in Chicago. If the court issues a temporary restraining order, I do expect that the Trump administration would immediately appeal that on an emergency basis to the Seventh Circuit and then to the Supreme Court and seek a stay of that order. At that point, it's a little difficult to know exactly what would happen. The Trump administration has seen sort of amazing success at the Supreme Court on the shadow docket, on its emergency docket, and these emergency claims to stay lower court orders, halting the administration's lawlessness. It may be counting on the Supreme Court issuing a stay in this case as well. And I think the theory for that would be that the courts really ought to be deferential to the government in determining when the government is unable to enforce the law or when there's a kind of rebellion that the government needs to deploy the National Guard for, a kind of deference argument, a sort of trust us argument, as opposed to digging into the details and looking closely at the merits. And the Supreme Court, quite candidly, the Supreme Court has granted the Trump administration victory on top of victory on its shadow docket on a similar kind of theory, a basically sort of trust us kind of theory. And so it's hard to say exactly what the Supreme Court would do with this case. But if history is any guide, the wind is certainly behind the Trump administration on this at the Supreme Court.
Stephen, it's still going on. The court hearing is still continuing. I want to ask you about this specifically. The judge has said that there's actual evidence that shows ICE started tear gassing, sounds like protesters, and then they put on the masks first. We keep hearing from the defense inside the courtroom. They're talking about things that could happen in the future rebellions, future things happening at the courthouse. Is that enough to bring up in court to have this go their way, to talk about the future, not something that's taking place right now?
It's a great question, and that's really so much of the back and forth here. So the Trump administration is saying that there's lawlessness and rioting. What the government is saying, the Illinois government and city of Chicago is saying, well, that's caused by the aggressive enforcement by ICE and the fact of deployment of the National Guard. In other words, the Trump administration is inspiring the very kind of lawlessness that it says that it's fighting against. And it's that back and forth that the courts are going to have to sort out. Everything that we've heard from the judge in today's hearing suggests that she's highly skeptical of the Trump administration's claims. I don't know that we'll see that same sort of skepticism if and when the Trump administration appeals a temporary restraining order in the higher courts. We'll just have to kind of wait and see how that plays out. But a large part of this is this sort of deference that the courts will traditionally give the government in a situation like this, that the deference the courts would give to the Trump administration in determining when they need to deploy the National Guard under federal law. This judge looks like it's not willing to give the judge or give the administration a ton of deference, but the higher courts might.
Stephen Schwinn, Professor, we appreciate you joining us and breaking this down and your thoughtful approach to what's going on. Thanks for joining us.